Health and Safety Code 11378 makes it a crime to possess methamphetamine for sales. So this is where you have possession of meth, and your purpose in possessing it is because you're selling it or dealing it. Now, normally, simple possession of methamphetamine for personal use is only a misdemeanor after Proposition 47. It's only a misdemeanor. It only carries a max of 1 year in jail, and you are eligible to do drug diversion. But if you have possession for sale, if you're convicted of possessing the drug for sale, then it's much more serious. It's a felony rather than a misdemeanor. It has a maximum sentence of 3 years in jail or prison, and you're not eligible for drug diversion. So it's much more serious. Now, people ask me all the time, what are the factors that would cause the police to arrest someone or the DA to charge someone with possession for sale rather than simple possession of meth? And the answer is there's a number of factors. The first, of course, is the quantity. If you have a large amount, if they find a pound of meth in your house, then the police are going to say, look, this is a lot more than a typical user would possess for their own personal use. The police will also look at the packaging. So if you have an 8-ball of meth and it's all in one baggie, that might suggest more that it's for your own personal use. But if you have it, let's say, in a bunch of separate bundles that each have a 1/4 gram, then the police are going to say, well, this packaging indicates that it was packaged for sales. The police will also look to see if you had a lot of money on you, especially small denominations, 20s, 10s, 5s. And they'll look to see if you were loitering or hanging out in an area where sales of methamphetamine are very common, such as MacArthur Park in Los Angeles. Now, here at Schaus Law Group, we've had a lot of success in representing clients and defending clients accused of possession for sale of meth. And we found that there's 3 primary defense strategies that are most common. The first is to assert that it was an illegal search and seizure. The second is to assert that the drugs didn't even belong to you. And the third is to assert that to the extent that you had meth, you had it only for your personal use and not for sales. So first of all, illegal search and seizure. It may be that the police searched you without a warrant or without probable cause to do so. Or it may be that they had a warrant, but the warrant was defective. Maybe they lied to the judge or provided misleading information in order to secure the warrant. In these cases, we can run a suppression motion and many times get the evidence thrown out of court. Second, it may be that the drugs didn't even belong to you. So for example, maybe you got pulled over and the police found some baggies of meth in your vehicle. But it may be that several people drive that car, or several people have access to it, and the drugs didn't belong to you, nor did you even realize that they were there. Finally, to the extent that you had some methamphetamine in your possession, it may be that you possessed it for your own personal use and that you had no intention of selling it or dealing it. In those cases, often we can get the charge reduced from possession for sale down to simple possession, which is a misdemeanor rather than a felony, and then get you into drug diversion under Proposition 36 or PC 1000, where you do a drug class, and if you complete it successfully, then you never go to jail, and the charge never goes down on your record.